Good morning, everyone, and welcome you all to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. As you all are aware, we have been conducting sessions on the new labor code. This is our third session on code on social security. Ms. Kinjal Mehta from Mehta and Mehta is taking the session today. Along with her, we have Mr. Bala and our panelist for today, Mr. Advocate Srinivas Rao Annasinghe Raju. He is the founder of Juris Dominus, a corporate legal firm providing strategic legal and compliance advisory services aligned with in-house counsel requirements. With over 25 years of experience, he brings deep expertise in corporate legal strategy, secretarial practices, and regulatory compliance across multiple industries, including manufacturing, IT and ITES, pharmaceuticals, cybersecurity, paper, and power sectors, serving both Indian companies and multinational companies. His core areas of specialization include corporate and contract laws, SEBI LODR, compliance, employment laws, mergers and acquisition, joint ventures, insolvency and bankruptcy, data protection, intellectual property, and legal due diligence. He has been instrumental in establishing corporate legal departments, compliance management systems, and contract management frameworks, and in drafting policies and SOPs that strengthen governance and mitigate risk. A seasoned professional, Mr. Rao has successfully led secretarial and legal functions for large listed organizations, navigated complex regulatory environments, and handled sensitive HR and governance matters with pragmatic business oriented approach. He holds qualifications including MCOM, LLB, FCS, Grad CMA, PMIR, and LW, and is a registered insolvency professional. We welcome you, sir. Before we start, we would like to hear your thoughts on the topic for today.
Good morning, all. Hope I am audible.
Yes, sir.
Good morning. Thank you for having me here. And I appreciate, first of all, the team's effort to convey such kind of an useful knowledge sharing session for the benefit of the professionals. Now, guys, we all know that the new labor codes are already in place, and there is some kind of myth and misinformation going on in the market, so that through these education sessions, we would like to communicate some kind of clarity and practical aspects of the labor codes. Of course, 4 codes in 4 weekly ways we are taking up. Now, coming to the topic, we all know that in India, the labor laws were ill-drafted or were maybe timed out. Most of the labor laws, we all know that actually during the British era. Now, the time has felt that the new laws has to be introduced in such a way to meet the current rapid changing society requirements. It's not that labor codes actually started in November 25 or maybe around 2020 or 2021. No. Actually, the idea started year 2002, date back nearly 23 years ago, I would like to say. It is the second commission, the National Commission on Labor, actually, which was at that time headed by Mr. Ravindra Verma under the government, which actually recommended, and prima facie they tried to cover at that time around 40 central laws which are covering the country in terms of labor related aspects. Of course, being a concurrent list, the states are also having nearly 140 laws on the labor items. Having finalized, they reduced in the initial years itself in the 2002, long ago, 4 codes to be introduced to absorb around 29 acts, so that we can actually cover the modern way of implementing the labor requirements of the industry. Later, actually, there was one more committee called Arjun Sen Gupta Committee, which was also constituted more for an unorganized sector point of view in the year 2006 itself. It's not that labor codes, as I said, started something today. Now, coming to the why these labor codes are not actually acts or legislation. Now, in the government felt, based on industry requirement and representation, that a detailed kind of analytical code should be in place rather than acts, like in similar lines with IBC code, which we are aware of. Now, when it comes to the implementation part of that, of course, again, there is some kind of mixed information, maybe with some half liars, YouTubers, influencers giving wrong inputs to the industry. We would like to address those kind of concerns to the extent possible to clarify you the actual position of the law. Now, coming to the implementation part of the labor codes are concerned, it is effective November 21st, 2025. There is no looking back. Central codes were already, the central code rules were already notified on December 30th. Unless there is a notification, they will come into force by now, February 14th, 2026. Of course, on certain topics, states may enhance and enact their own rules and regulations. Nearly one-third states are already rolled out. Even Maharashtra rules were in public domain from the year 21-22. Of course, they may make for some final tweak and changes to the law and notify that. So it's not correct to say that codes are effective 1st April. Maybe that the way we can say that by that time, by and large, most of the states would be enacting their own part of the rules. Until that, obviously, the central labor codes are in place. Now, when we discuss these central codes, there are many things which we have not heard about, which are required, which is the order of the day, were duly considered by the government. Now it comes to ease of doing business. That is the primary target the government of India having when they are pushing the labor codes. But there is a catch-11 situation here. Whenever they are enacting the provisions uh, to favor the employer to give some kind of ease of doing business, at the same time there is a catch-22 situation where it is maybe looking like not good doing justification to the employees. That's why it happened like a zero-sum game. The code actually tried to rationalize and simplify many things in such a way so that both the industry professionals and of course the employees, the impacted community, when we say here the worker or employee, the significant change of the four labor codes, I can say hardly it is not touching a regular employee who is on the full-time employment of a company. The more government perspective is to cover the unorganized sector. That's why we would have heard the word, many new words which we were using on a social media, like the gig worker, the platform worker. Instead of cine worker, now we are using audio video worker. I'm sure Kinjal is going to cover all these in her detailed presentation. A home-based worker, wage worker, interstate migrant workers, even last but not least, the sales promotion employees. So all these people were brought under the code. Now you would be wondering what is the rationale. If you see in last 5 to 10 years, the lifestyles have been changed. Sab ghar baithe baithe, whether it is Swiggy, Zomato, anything you call Zepto. So there's a lot of manpower requirement in the industry, and it actually absorbed these gig platform workers, a lot of community which are in unemployment. So now there is a lot of activity, and these people are getting a lot of employment opportunity. But these people were not covered per se under any law, time being in force. So where government thought as a perspective to bring all these manpower also, now you will be surprised to see that in India, roughly 90% of the manpower working, that turns to be around nearly 45 crores, are in unorganized sector. Who will take care of them when they are falling ill or in case of a death, in case of eventuality? So the government brought these all changes with those perspective, not to just put a burden. It wanted to give a kind of level playing field as far as the new codes are concerned. Now, when we see as far as this particular code is also concerned, the Social Security Code, which is one of the important aspects covering nearly 9 legislations, this code represents a paradigm shift towards inclusive welfare for India's vast and often neglected informal workforce. Having said that, that is the crux. Just to say that it made life very easy for both the sides, as I said, from employer or employee side. Previously, employers were required to maintain nearly 84 odd registers physically. Of course, many people from IT or service industry may not be aware, thinking that this is a case of factory or production setup. I would like to shatter one more myth. Under new labor codes, there is nothing called factory or service industry. all codes are equally applicable to all the industry just based on your nature of activity. So the important one, which we may say the Occupational Safety and Health Code, which may be a replica of Factories Act, not applicable to service industry, is wrong. Nearly half of our provisions, probably crisscross, we are talking today also, would be covered under the OSH code, which are equally applicable to IT and service industry. So we need to keep in mind these kind of things. From 84 registers, they now rationalize it to 8 registers. Previously, there is a kind of jail in case of any violation, which was those provisions enacting for 29 acts is nearly 87 instances. Now, government as a part of towards ease of doing business, encouraging employers to comply and proceed with the business. That is the intention. From 87 jail provisions, it reduced to 22. Out of which also there is a chance of compounding, but it is not easy now. Someone can comment that employees were let off not complying this. No, it's not the case. Previously, if we see the penalties for any non-compliance were 500 rupees, 1000 bucks like that. Now, most of the penalties are enhanced to 1000, 1 lakh or 2 lakh as a base so that employees also can feel pinch of this so that they will think twice before violating any of this. And many provisions were actually brought under digitalization. Of course, largely with the internet and computer, we are doing many things on Excel or other software utilities. But now the courts actually blessed few of the things by giving a kind of level playing field to bring on the digitalization. And some of the important aspects I will touch base while the presentation going on, wherever required, I will add some of that. And last but not least, few of the major points I would like to say as a big relief, as a law student, we all would have also realized bringing multiple definitions under new definitions with a equal meaning in each code. Previously, the biggest problem for us while we were academically preparing, the words like employee, employer, worker, wage, each thing was differently defined. The good news is that the code brought so much of uniformity in definitions, whether it is called dependent or I call EF factor, employee, employer, employment injury, establishment, family, factory, manufacturing process, all these critical things which are day-to-day requirement of industry are given uniform meaning under all 4 codes. Of course, to match with the current changes, it also brought several new definitions. Just to touch some of the major is the Central Provident Fund Commissioner. Even interestingly, guys, the word company is first time defined under labor codes. It is worth to note that company includes LLP, but labor codes again interestingly left out by not consciously including foreign incorporates in India. So let us see how it is going to unfold when the codes are actually implemented. And some of other definitions are like railway, even vacancy under Employment Exchange Act. What is vacancy? Which are all subjective, creating confusion or subject matter of litigation. Government try to address in a clear way so that we can all have a clarity in implementing those labor code provisions for the benefit of the industry, both from the employer or workforce community side. The most important definition, the new one I like to see is social security. We all generally use these words. What is social security? And in employment exchange, that word was even removed. Now they are using career center. So all these things we will come to see in the from the next financial year. Actually, as a professional or as an industry guy, we are actually going to use them. So with these initial remarks, I request Kinjal to take over the session. And as the presentation progresses, we will try to clarify not only the theoretical aspect, wherever to the extent possible, the practical aspects of the labor codes in specific as far as social security code is concerned. Thank you.
Thank you, sir. Thank you for the introduction. Kinjal, over to you.
Sure. Will Bala sir like to say anything?
I think he's logged off. You can.
So you're on mute. Bala sir, you're on mute.
Yeah, good morning to all of you. I have a great pleasure in welcoming you all on my own behalf and also on Mehta and Mehta's behalf. And Mr. Srinivasa Rao has already addressed the whole of the things at a stretch. So I don't want to add many things, but at the same time, by going through the code, what it appears to be, the code is definitely aiming to provide the dignified and financial security for every worker. gig worker, platform worker, even aggregator like Uber and Ola, where we are actually engaging the services, etc. All those things has been actually brought in here. Now, probably if the code gets fully implemented, there will be, yes, protection will be strengthened, especially with reference to the women, where we are talking about the women empowerment. So women will get a comprehensive maternity benefits and plus the nursing breaks and plus promoting workforce inclusion, etc. That is what it is expected. Another thing is that the ease of doing a business he touched upon. Lot of compliances have been brought down to the minimum level and things have been made on the digital base. That is another thing is there. So that is definitely going to help. And another thing is that we look at it is not only from one side, it is actually from both the side, employee and the employer, both. It is taking care of the total benefits actually, because especially the insurance health, which was not there in many of the sector which were left out, gratuity which was not there for the people who are actually working for the short-term period. All those things have been actually brought in this. Now, what is actually stored for the company secretaries? Most of the company secretaries are also working in the different industries, especially in the manufacturing industries as well. So first and foremost thing, the awareness has to be brought in. That is one thing. Awareness is from top level to the middle level, senior management, local level, that is required. Another thing is all the interdepartmental, because everybody is involved. Because when you talk about the wage is redefined. Now financial impact, finance department is involved. HR policies are involved actually. Operations, the various things have to be taken out. So what is called for is actually, awareness is to be brought out. Company secretary has got a lot of role to play, because in the Companies Act, it is clearly mentioned one of the functions of the company secretary is not only ensuring the applicable, not only ensuring the company laws, but also ensuring the company complies with all the other applicable laws to the organization. That is very important. So from that perspective, there is everybody has to learn. It is a new process. We are in the learning. Today, we have a benefit of Mr. Srinivas who will be sharing his practical experiences, he will be giving the clarification, etc. But still, I just wanted to add, we are still in the learning age. As we go along, as we travel along, we will see. Not only that, we may expect more clarification, we may expect more circular, we may expect more modification might actually take place. That is one thing. So today we will try our level best to provide analyzing the code, whatever the things are there and relevancy. That is one thing. And as usual, I will request all the participants to put their queries on the chat box, which will be taking out from time to time. And depending upon the time availability at the end, we will also permit you to raise your hands. You can also speak. Over to Kinjal, please.
Yes. Hi, everyone. Good morning.
Yeah, it is visible. You have to put it in the presentation mode.
Yes.
Yeah, perfect.
Yes. Good morning, everyone. So today, as we know, we're going to be talking about the third code that has been issued, which is the Code on Social Security. Now, this code again comes in replacement and updation of many outdated laws that existed before when it came to Social Security. So let's get on to it. So before, like I mentioned, there was a lot of legal complexity. There were too many different acts with too many different definitions, a lot of ambiguity and all, which this code tries to eliminate. There were coverage gaps. Not all workers were included, which this code tries to overcome. And it's basically an update to how the industry looks like today, and ensuring that the laws align with that. So the code is essentially replacing older acts that include the Employees Providence Fund Act, the Maternity Benefit Act, the Payment of Gratuity Act, the Employee Compensation Act, the Employee State Insurance Act, the Cine Workers Welfare Fund Act, the Building and Other Construction Workers Welfare Cess Act, and the Unorganized Workers Social Security Act, the Employment Exchanges Compulsory Notification of Vacancies Act. So this one particular code combines all of these acts and consolidates into one uniform way in which all of these social benefits will be covered today. So let's just look into what problems the industry was facing because of which these codes were required. So one of the main issues was there were too many multiple laws, too many different benefits, too many different laws that govern different benefits. There was a lot of overlapping. There was a lot of ambiguity within these acts. There was different definitions. So due to the lack of clarity, different with when it comes to different provisions, definitions, enforcement mechanisms, compliance procedures. There was a lot of confusion, contradictory interpretations, disputes, and litigation. So whenever there was any kind of interpretation issue and all, it always landed up in court, overwhelming the courts essentially. Then there was, like I mentioned, ambiguous definitions when it came to employees, wages, establishments, and they were differently defined under various laws, and which created again disputes for eligibility of benefits, any kind of judicial interpretations, and how to comply with all of this essentially. So it just became a big headache for all of them, because then the inspectors would come, slap a fine and things like that. Then there was very limited coverage in terms of the workers were concerned. So the time during which these acts were introduced, some of them even pre independence, the scenario of the industry looked very different. And today, the way in which the industry operates is very different. The acts didn't keep up with all of these requirements, and a lot of workers were left out. So these large portion of workers included the unorganized sector, the workers in the gig and platform models, which we'll be discussing later, which did not fall under the formal social security schemes. Um, Before, these laws couldn't envision these categories, and which left millions of people out of social security benefits like provident funds, insurance, pension, maternity, and other such important benefits. There was a lot of compliance burden and administrative difficulties. So employers faced heavy paperwork, physical registers to be maintained, filing of returns on different portals under different acts. There was repeated inspections, and this just made life very difficult for all employers. Then there was inefficient enforcement and outdated penalties, like Bala and our panelists mentioned, that penalties under the older law were not updated. They varied widely. They weren't aligned with the level of non-compliance. Enforcement of all of these laws was very weak and inconsistent basis the inspector Raj that existed. Now, the reduced deterrence and compliance effectiveness really impacted the way industries functioned under the previous laws. Then there was no there was just inequity for workers, since they were not all properly covered. It became very difficult for them to claim and ask employers to be paying the benefits that they were entitled to. So, looking at these issues, over time, these issues that were identified and were worked upon, and coming to today, the government is through these laws and codes attempting to navigate and resolve these issues and better work around it. Now, let's look at the applicability of this code. There are so the applicability has more or less remained similar, except for a few changes. So before there was act specific thresholds and conditions, but now since we have one uniform law, the applicability now is more uniform under this particular one law which has been defined. So looking at EPF, it is applicable to establishments with 20 or more employees. But before it was only applicable to establishments that were listed in notified schedules and all, but now it's applicable to all establishments with 20 or more employees. Coming to employee state insurance, so we are looking at applicability to all establishments having 10 or more employees. Previously, this was only the case, but now it has been made mandatory for any establishment in hazardous sector to be registered and come under the employee state insurance applicability. Then coming to maternity, we're looking at applicable to all establishments having 10 or more employees. This is in line with what was there previously, and gratuity, the applicability is for establishments with again 10 or more employees. So before, when we were looking at counting these number of employees for its applicability, there was a lot of ambiguity in terms of who is to be included. Only those certain employees that fall within the wage ceiling should be included. Should all the employees should be included when you're looking at counting them for the applicability of these laws? But this has now been clarified, saying that all employees must be counted to check for applicability of these laws.
There's a related question is actually put up for petrol pumps having a employees less than 10, whether registration under the ESI is actually compulsory. Srinivas?
Yeah, couple of points. Previously, the ESIC limit was 20. Now it is reduced to 10. Please take a note of it. Having said that, any organization having less than 10 are not required to register under ESIC, point 1. But if your particular industry is now going to be notified as a hazardous industry, then regardless of 10 or even 1, you must have ESIC registration. As far as petrol bunk specific is concerned, we need to await the notification whether under new labor codes are they going to notify it as a hazardous process or not.
Srinivas, I also think the pumping of the oil is deemed to be a manufacturing. That is what I understand, number one. Number two is this, all these petrol pumps, I think earlier it is all covered under the shop and establishment registration.
Yes.
That is what it is. Shop and establishment registration is coming under the state law. I don't think in the labor code, the shop and establishment has been actually covered as such. So that is a confusion I have actually.
Very interesting point, sir. You raise it for the benefit of forum. I would like to expand. When actually the government and the committees sat for designing of the code, the first law they considered to be included was Shops and Establishments Act. Now, in a federal mechanism, it is very difficult to snatch away the powers of the states. That's why to have at least some kind of smooth beginning, the Shops and Establishment Act is not considered under the labor codes. If something is covered under shops and establishments, as per previous position of the law, it cannot be said into the manufacturing process because both are oxymoron to each other. If you are in any kind of manufacturing or production kind of setup, obviously you must be obtaining a factory license. There you are not required to again have a double registration under shops and establishment. So timing, this will clarify that petrol pump is either a shop or a factory.
Yeah, because I also saw some of the interesting judgment earlier, some of the courts actually, which is actually given. I am not able to exactly quote which court actually, because the pumping oil is considered as a manufacturing processes. They actually made it the petrol pump potentially fall under the Factories Act. They are allowed to take a Factories Act license. And again, coming to your same point, it is being on the concurrent list. There is a central Factories Act is there. There is a state Factories Act there. So wherever the petrol pump situated in the particular state, they are supposed to follow the state rule. They are supposed to get the factory license under the state Factories Act. That's what I think. Yeah.
Exactly. And also a couple of queries I'm seeing on the chat box related to this. Someone raised a query that 10 or more women employees or any gender as far as maternity benefit is concerned. The law is actually gender specific in India as we speak today, including the labor codes. Obviously, but having said that, if the employee strength is crossed 10 or more, and only even one among them is woman employee, she is entitled to the maternity benefit. That is the logic.
Yes, that was the confusion that also existed before, that should the relevant employees be counted or all employees be counted, and the law is clarified that all employees should be
All
counted.
employees, absolutely.
Yeah, all employees should be counted, the benefit to be extended. The whole idea is they wanted to cover all the sectors. They don't want to leave out any uncovered people. That's the whole idea.
Some more questions I am seeing that whether lawyers, CA firm, doctors are covered or not under the labor codes. See, time being, if we see, as we already discussed the Shops and Establishment Act, none of these forms are actually required to obtain any kind of Shop Act license. When you are not subjected to that kind of licensing registration, we don't think so that labor codes are applicable per se as we speak today to a particular CA firm or as far as any lawyer firm is concerned.
But the law is not clear as of right now, because all they have mentioned is establishment with the said threshold for employees and workers. So yeah. So then the center level rules will need to come out when it comes to this.
Yeah,
One
that is
more,
what I
one more query, Kinjal, on bonus. That please clarify whether bonus will be applicable to the trainees as per the new code. It was covered under the old act. The new code says that every employee, then I have to refer the definition of employee. The employee definition says that other than apprentice, under apprentice act, everyone, whether skilled, unskilled, managerial, supervisory, all are covered under the bonus act. So now in your given case, you have to understand whether your trainee is designated under Apprentice Act or just because he's a new entrant in the job, you are designating him as a trainee. That will decide whether bonus is applicable or not. Otherwise, per se, it is applicable.
Yeah, one thing is rightly you said to Srinivas, what happens is on the Apprentice Act, it's a specific requirement where people have to undergo a particular training. So that is covered under the Apprentice Act. But whereas what happens is in case of the training, the organization wanted to offer a job for a particular person. But the thing is, they want to get them trained to the company's, manufacturing processes, this, etc. So initially, he has been actually put up under the training period where they call it as a trainee. It is as good as the employee only.
Absolutely,
So
sir.
as such, it will be covered actually. That is what the interpretation on us to go broadly. I think again, coming back, that, to due respect to all our professional, our CS fraternity, when we start learning the CS program, the fundamental, what is the Constitution of India and the interpretation of the Act. So that is where it is actually carried professionally. We'll have to interpret, we'll have to advise correctly to the management. Yeah.
One more query that will PF be applicable to fixed term contractual staff? I would like to say a few things here for the benefit of the forum, not the query specific. If you see, the new 4 labor codes actually repealed or covered how many legislations? We all know 29. But whether Government of India actually notified how many legislations under labor code today as we speak, 29 is not the correct answer. It is 28. Please read the Gazette. It clearly excluded the Provident Fund Act time being. Even though it is covered under the Labor Code, it is not notified. So please, forum, note that PF is time being not notified under new labor codes. What does it mean? That means that PF Act stands on its own as before, as we discussed today. And the previously how the PF provisions are applicable, that is continued. Actually, one of the strong myth created on that is now under new labor codes, wage to be 50% of the salary or payment, then PF also to be paid on 50% of the salary. This created a terror in the industry. Even that is true if we assume currently also under PF Act, there is a rider provision we conveniently forgot that for the purpose of calculation of Provident Fund, the PF wage will be restricted to 15,000 per month. That's why 1,800 per month is the calculation arriving at. So that still holds good. And if fixed term contractual staff are, I don't think so, covered under the PF Act as it stands today. So there is no such a provision under Labor Code also, unless while notifying the Provident Fund Act under the Labor Codes, it is included but not notified. We may have to wait for that changes. And also someone said that today's newspaper stated the courts will be effective. No, it is not that. If you clearly read the minister's statement, courts are effective November 21st. It is evident from the ESIC department of multiple notifications clearly mentioning the 50% wages as far as ESIC purpose is concerned. November 21st, they are already in touch with organizations calling the employers to comply the law. November is already gone. December compliance date is almost over. Now January is waiting for you for as far as ESIC is concerned. What minister meant to say was the central rules which were notified on 30th December would automatically come into picture on February 14th, 26. But there is a representation from the industry so that they may decide how to implement it, maybe in a phased manner or maybe deciding as a November, April 1st as the next effective date. Otherwise, the codes are effective from November 21st. Bala sir, you are adding something.
No, you rightly said actually, because the code is effective from 21st of November when it is actually notified, that is a reality. Second thing is the rules. As you rightly said also, it is being on the concurrent list. But with reference to the geographical continuation, the working back, the backward developed areas, etc., and other thing and all, state will be coming with the specified rules where the draft rules are already ready with the most of the states. So as per the news, as I said in the beginning also, it is all expected the more or less the full implementation with reference to state and central rules coming into the picture will be taking place from 1st of April. That is the whole idea. It is not everything is going to take from 1st of April. Its code has already actually come. That is the issue here. One more question is there. What about the cooking gas agencies, whether they are actually considered as hazardous?
Cooking
gas agencies, whether they are considered as hazardous.
That's why as far as new labor codes are concerned, regardless of the previous Factories Act notifications, we have to wait for the government to issue a schedule of the companies which are going to be described. So we don't have the ready list now to say yes or no. So we have to await for the confirmation, which is industry specific. One more question on this slide. Kinjal, we are taking a little more time based because the questions are relevant to this slide. Just whether PF registration is required for a OPC, which is into manpower skilling. OPC, when we said company means company defined under Companies Act, which covers OPC, point 1. Manpower skilling activity here, regardless of that, if the strength is 20 or more, it has to go for PF registration. Hope this clarifies.
For infrastructure companies having the project for certain period and a place on site covered under shop and establishment or a factory site.
See, it depends on, again, state specific, but prima facie, we are seeing currently the infrastructure companies are complying with shop establishment registration as far as employment is concerned, because they are operating like a typical road project companies operating in multi-states. They are obtaining for the shops and establishment registration.
If the company are having a more than one site, the limit of 20 is taken based a particular site or in the total overall strength.
The law is talking about the company, not the site specific. So the moment company crosses 20 or more, it has to register. Obviously, they have to cover all the employees working throughout in multiple sites.
Somebody has put actually maximum hours of overtime in a quarter. To be very frank with you,
I
there has
have the
been
answer, sir. I have the answer.
yeah.
I'm recollecting from that. The maximum overtime, even though the law provides for overtime has to be paid double wages, all this perfect, but it can't be in such a that the employee health may be in peril. The maximum limitation is time being notified, particularly in Maharashtra also, is 125 hours per quarter. Hope I clarified this.
Yeah, you're actually right. But since I have been associated with the manufacturing industries, at times, even the earlier act also, the overtime used to be exceeded in some of the specific cases actually. There used to be an inspection. Those days we used to have the inspector who used to come. You may be recalling Srinivasa Rao, those days facing the inspector was a marathon task actually. So he used to come. When he used to come, he will go through it. But conveniently, when it comes to the excess of the overtime, he will ignore it because he will actually consider this is going to be the benefit to the employees, why to bother. That used to be the case. That is what I have actually witnessed in my practical experience, even those days. But as you rightly said, yes, the restrictions brought basically to safeguard the health, actually. That is the concern. Yeah.
One interesting query that we pay leave encashment annually, and whether we can pay this December 25 leave as per old basic salary and in future as per new salary. I'm trying to address to the forum through this query as far as ESIC, gratuity, even an employee left in the month of December, the full and final settlement is concerned, you must be providing as per new wage code only. There is no reprieve. If you see, to corroborate that accounting standard 19, even the ICA Institute also clearly clarified how to book the past period related employee cost. So you have to join the dots. Not only this PF or gratuity or F&F settlement, everything must be under new wage code. Yes, it is difficult because you have not provided for throughout that year for that employee. By talking about one employee, on a given period, you may be having 1,000 employees on roll. It is a hit, yes. That's why TCS has provided 1,300 crore hit. Infosys provided for 2,000 crore hit as far as their balance sheet is concerned. So it is a alert to the industry through these webinars. We are trying to educate you people that please work immediately on the labor codes. Don't wait for April 26.
Yeah, this again, calls for the interpretation of the act. Again, the interpretation skill is actually called for. And again, it calls for the better coordination with the inter-department, where the professional like company secretaries have to play a lot of role. Yeah. Yes, Kinjal, go ahead. We'll take up the
Go ahead.
questions later.
Questions are coming out. Anyway, you please proceed.
Yeah.
We will pause next time.
Right. Right. So coming to the definitions under this code, there are certain. So again, I'll just highlight that this code is quite vast. We will be looking into majorly the changes that have come about, and focusing on that. So one of the major changes that has essentially shaken the industry is the new definition of wages, which, if you'll notice, is uniform across all codes. So wages under this code specifically includes basic pay, which is the foundational fixed component of the salary package, the dearness allowance, which is an allowance paid to offset the impact of inflation. And then you have the retaining allowance, which is an allowance which is paid to the worker in case a machinery breaks down or if there's a downtime. Then this or any off-season payments that are made to employees to retain them. Apart from this, anything apart from this, the code excludes under the definition of wages. So these exclusions include any bonus payments, any kind of house accommodation benefits that are provided, any kind of supply of utilities, any contributions paid by the employer for any pension provident funds, any reimbursements in any house rent allowance, any award settlement, any kind of commissions, gratuity, retrenchment compensation. All of these things have been specifically excluded under the definition of wages. Now, if this excluded part of wages exceeds 50% of the total wages paid to the worker, then this additional over and above the 50% will be added to the computation of wages. So this is a landmark change which we are expecting to impact the cost of an employer when it comes to payments of benefits for its employees. So we're looking at impact on EPF, ESI, bonus, and overtime payments. Coming to other new definitions, so a gig worker is a new definition which has been introduced under this code. Now, a gig worker is defined to be a person who performs work or participates in a work arrangement outside the traditional employer-employee relationship and earns from such activities. So these are short-term, task-based and assignment-based, payments that are done to these workers. There is no formal contract of employment. There may be some other contract, but there is no contract of employment. There may not be any formal contract of employment. They may work in multiple entities with multiple individuals all at the same time and not be restricted to one particular entity and employer. Workers, they may be working online, offline, and the payment made to these kind of workers is usually per task, per project, per assignment. Examples under this includes freelance graphic designer, content writer, event photographer, part-time consultant, delivery agent, engaged by a local shop, etc. Then the second definition, which has been introduced under this code, is the platform worker. Now, platform worker has been defined as a type of it has been defined as a person engaged in undertaking platform work. So these are individuals who undertake work through an online digital platform, and they are paid for their services through this particular platform. So the work is mediated through a digital or online platform. The platform uses algorithms, apps, websites to match workers with customers. Work is typically app-based and technology-driven. And the platform may control pricing, access to customers, and performance metrics. These include workers and ride-hailing drivers, in app-based taxi drivers, food delivery partners, app-based home service providers, online freelance marketplaces. So we're looking at all your Zomato, Swiggy, Uber, Ola, etc. So essentially, if we kind of look deep dive into the definition, we can say that all platform workers could be gig workers, but not essentially all gig workers are platform workers. They are excluded. They're not employees in its traditional sense, and they are covered under separate social security schemes that is framed by the government. And the coverage is through welfare schemes and not your traditional EPF, ESI employment benefits. So now the central government is tasked with framing and notifying suitable social security schemes for life, disability cover, accident insurance, health, maternity benefits, old age protection, etc. So yes. Then the next new definition that has been introduced is the home-based worker. A home-based worker is a person who produces goods or services for an employer in their own home or premises of their choice rather than at an employer's premises and workplace in exchange for a remuneration. This sorry. So unorganized worker is the definition that has been introduced under the code and is defined as a home-based worker, a self-employed worker, or a wage worker in the unorganized sector. Now, the unorganized sector has been defined as an enterprise owned by individuals or self-employed workers engaged in production of goods or services where total number of workers employed is less than 10. So all establishments having workers less than 10 are covered under the unorganized sector. Now, delving into the three definitions that the unorganized worker covers, one being the home-based worker who works from home, and the second being self-employed worker, a person engaged in occupation in the unorganized sector who is not employed by any employer but earns a monthly amount, which will be notified later. And then you have the wage worker, is a person who employed for remuneration in the unorganized sector, whether directly or through a contractor or by a household. So this aims to cover your domestic help also, and it includes temporary, casual, or migrant workers within notified wage limits, and these will be notified. So the welfare schemes and benefits are to be notified by the central government, state government, and we will see what kind of coverage they will be getting. The funding for these schemes will be done by central government, state governments, uh, contributions by beneficiaries, employers, and CSR also we are looking at. Coming to the next definition, which is contract labor. So contract labor is a worker. A worker is deemed to be contract labor when they are hired in connection with the work of an establishment or through a contractor, regardless whether the principal employer knows of the arrangement or no. There are specific inclusions and exclusions. So it specifically includes interstate migrant workers, but excludes workers who are regularly employed by a contractor on permanent basis with mutually accepted standards, such as periodical pay increments and existing social security coverage. Now, when you're looking at contract labor, the Act also defines the contractor. So, a contractor is defined as a person who either undertakes to produce a specific result for an establishment beyond just supplying goods or simply supplies contract labor as human resources. So, so this definition also specifically includes subcontractors, and it recognizes contractor as an employer. Now, when it comes to responsibility for social security contributions, so PF, ESI, etc., are either directly paid by the key employer or by the contractor. And in case it is paid by an employer who employs these contractors, then this employer is has the right to recover full amount of such contributions made by him for the contract workers from this contractor.
One more question is actually asked by a person here. Rickshaw driver, Tonga driver, and pushcart seller come under which category? That is what he is actually saying that. I will definitely wait for Srinivas Rao's answer on that. But according to me, what it comes to my mind is they are all, self-employed people
Exactly.
or self-employed entrepreneur. That is what I would say. Over to Srinivas Rao.
The golden rule is, in case of doubt, stick to basics. So whether there is a organization, industry or establishment engaging them, the answer is no. Obviously, self-employed or these kind of people are not covered. Couple of points I would like to add on this slide and maybe couple of queries related to ESIC for the benefit of the forum. First time under labor codes, it clearly articulated that your core activity cannot be outsourced. So once industry understands this provision, digest, maybe they will get their own shockers in the month of April and May. People may be in slumber, they are not realizing. Today, I am in an IT industry. I have 100 employees, what we call the fancy word, FTE, full-time employee, not fixed-term employee, HR jargons. Okay, I am also having another 400 people, what we call in IT Bhasha, consultants, contractors. What is my main core activity? Is the same IT project-based services. Can I outsource? The law clearly says labor code. The labor code clearly says that only with 3 exceptions, the core activity can be outsourced. So that means if you are not fitting into those 3 exceptions, you cannot outsource your core activity. Everyone knows if it is of a seasonal nature business, obviously you can outsource. If it is there is a sudden rush and you have to manage a lot of kind of traffic like during Deepavali, Sankranti in South, you have to have a surge, you have to manage. Then obviously you need a short-term manpower. That can be outsourced regardless of whether your core activity. The third one is probably that if this is the natural case of your industry nature, where work is generally outsourced. So in that kind of 3 scenarios only, otherwise core activity cannot be outsourced. Professionals who are party to this session, please go back and check your client's core activity and shatter the misunderstanding if at all they are carrying after November 21st. One more thing, Bala sir, I would like to attend to the forum. Of course, there are multiple questions. Instead of reading every question, we want to give clarity on the ESIC wage salary, which is the most impacting one. You need to understand why ESIC department was aggressive since labor codes were announced. If you see in India, the PF number, I'm just giving for example, say, there are the PF authorities having around 30 crore members on board. As far as ESIC is concerned, they are hardly having 10 crore number. That is the difference of the ratio. The wage definition now gave beautiful opportunity for ESIC organization to settle scores where industry used bypassing provisions in the past and engaging people but showing them as a contractor or outsourced and not covering them under the ESIC. That's why if you see the December 13th notification of ESIC department, of course in 17 they confused with one more notification on December. Again, they re-articulated on December 30th. Please do read the circular. They are going to empower and enforce the labor code from November 21st. Okay, they may not be knocking your door as we speak on January 17th. When they come to your client on March or April, they would be reckoning ESIC compliance from November 21st. At the most, there is a talk in the industry that probably for November and December, they may take a lenient view, but we cannot assure that because December 30th was the notification date. So for January, at least try to comply ESIC immediately. Now, as far as many queries on ESIC salary is concerned, don't go into confusing explanations, 21,000 basic high, this allowance, that allowance, old salary, don't. If a employee wage is 42,000 se jada, means 42,001 rupee is his wage, he is not under the ESIC. This should be your thumb rule. if his salary is 42,000 also and below, obviously being 50% of the basic, 21,000 rules applicable. So instead of studying multiple components of the salary, try to see whether that particular employee salary is beyond 42,000 or not to include in the ESIC. Hope I have clarified to many queries posted on the groups as far as ESIC is concerned. And also one more query I would like to add at the same breath. Someone mentioned that one employee left in the November and still as we speak, we have not done their F&F. Whether there is a violation and there is a consequence. Consequence we can read in the book. Yes, it is a non-compliance. But please understand the forum. The law mentioned the word is not full and final settlement. We have a habit of using our general usage words. The law said that within 48 hours, the wages to be paid. It never mentioned F&F. There are practical challenges. Industry will settle to some practical challenges. How? Like if employee is sitting with company asset, company employee is sitting with lot of stock which is worth lakhs or crores. Obviously, F&F is not possible. But how the law mentioned is don't stop the wages, keeping any other reasons. So please do pay his wages immediately at least to avoid any further complications. And someone put a art query, I would say art query, why if someone is working with multiple organizations. Generally, if it is organized employment in a establishment or a industry factory, most of the state laws and shop acts clearly says dual employment is not legal. Secondly, most of the companies policy also says dual employment is not legal. So I could not comprehend a proper answer. If he's like an ad hoc basis is working like a self-employed guy, like probably he would like to apply this to the moonlighting happened during the lockdown period and continuing now. God bless them until they were caught by a employer or the legal authority.
No, to be very frank with you, Srinivas Rao, here, when you are talking the employment, we will have to take a help of the income tax. Whether that person is getting a Form 16 or Form 16A, that will decide the nature of the employment. If he is getting Form 16, he is employed by the employment. That's the thing. It is actually a contractual obligation of the employee and the employer. So he issues Form 16. He is actually employee, and he cannot take a multiple job. In fact, there has been cases even under the Companies Act. It has been found there was a finance manager who was employed in 2 companies. He was heavily penalized. So that will definitely amount to the non-compliance that will be there. But on the contrary, if you actually said, is sort of the consultancy, that means he is on his own, he is rendering his services, which means this is coming under the TDS, that is 16A. If that 16A comes, there is nothing. He can do whatever he wants. That is the question here. We can take a help of that. We'll have to see. Somebody has put
One
up a
interesting question, sir.
Yeah.
One more interesting question here. Someone put till how long this seminar will go on. The official designated time, my dear, is 11 to 1. But based on the feedback from the participants in the past, we are putting more focus on the Q&A session to help you rather just wrapping up our presentation. So that's why we are actually reading the questions and providing the answers in between the session rather allowing Kinjal to complete her presentation.
Yeah,
So
in fact,
level
I'll have
2
to
is the
allow.
official time.
Yeah, we have to allow the Kinjal to complete the presentation, number 1. Number 2 is, as you rightly say, official time is 1 o'clock. We may take another 10-15 minutes, but not later than 1:30. If number of questions are more and other things and all, probably we will get back to you individually. But the problem is we may not be able to prolong beyond that. That is a thing which I would like to say. One interesting
last
thing people.
question before Kinjal can start. We have only 2 employees. Whether gratuity to be covered, the answer is no. There is a clear threshold limit Kinjal already shown. Unless you cross that number, gratuity is not applicable.
Kinjal, you go ahead. Now we won't take up the question. We want you to complete the presentation. Then we'll take up the questions. Yeah.
Sure. Coming to the next definition, employee. Now, employee under this code is and is uniform with other codes, and it has expanded the coverage. Now, it specifically excludes apprentice and armed forces. Apart from that, Employee is any person employed on wages by an establishment to perform any type of work, be it skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, clerical, etc., etc. Mode of employment could be direct or through a contractor. Even if it is through a contractor, if they are covered under as an employee. And the terms of the employment could be expressed, implied. Yeah, and for the employees so provided for the purpose of PF and ESI, employee shall mean such employee drawing wages less than or equal to the wage ceiling, which will be notified by central government. For now, ESI is 21,000, PF 15,000. And yeah, so we will have to see how, if anything new is notified under this code. Next definition, we look at employer. Employer is defined as a person who employs one or more employees in their establishment directly or through a contractor or for any person. This so and With this definition, they are required to fulfill certain responsibilities under the code. Now, there are specific uh, clarifications also provided for employer under this code. So, basis different establishments. So, for a factory, the occupier of the factory or the person with the ultimate control over its affairs is considered the employer. For mines, it's the owner or agent or manager of the mine who's the designated employer. For government departments, the head of the department is considered if no authority is specified. For local authorities, the chief executive of that authority is considered the employer. And for any general establishments, the person authority having the ultimate control over the affairs of the establishment is considered an employer. For contractors, it includes contractors as an employer. It also includes the legal representative of a deceased employer when it comes to fulfilling certain responsibilities under this code. Then aggregator is also another definition that has been introduced under this code. It is defined as a digital intermediary or a marketplace that connects buyer or user of a service with the seller or service provider. Now, the seventh schedule specifies these different types of categories for aggregators. One is ride sharing services, which covers your Ola, Uber, food and grocery delivery services, Zomato, Swiggy, and logistics services. Other e marketplaces, both marketplace and inventory models. All your Amazon, Nika, everyone. For wholesale and retail goods, any kind of professional service providers, healthcare, travel, hospitality, content and media services, everything has been covered under all your online, operators have essentially been covered under this code. Now, the code requires the central government and the state government to form schemes for the role of the aggregators. And the code requires contribution by these aggregators between 1 to 2%, but with a cap of 5% of how much they are required to pay their gig workers for to create a welfare fund that would fund the gig and platform workers that work for these aggregators. Building and other construction work has also been defined. It includes so building and construction includes your building of civil infrastructure, water, power, technical installations, large scale structures, but it explicitly excludes any work related to any factory or mine, and it also excludes residential work for individuals or groups with having the total cost which does not exceed 50 lakh rupees. And the benefits for such workers is provided under a special welfare fund. So schemes need to be notified by central and state government to frame schemes for unorganized workers to provide them social security protection, which will be financed through government, employers, and even CSR for that matter. For building and other construction work, um, a cess is to be levied between 1 to 2% of the cost of construction to be paid by the employer to create a fund, um, which is your state building and other construction workers welfare fund, to cover the social security benefits for construction workers. The code also defines interstate migrant workers. This is a person who is employed in an establishment, um, who who has been recruited in one state for employment in an establishment located in another state, either directly or indirectly through a contractor. And he has traveled on his own from one state to another and obtained employment in the establishment in another state. There is a wage ceiling to be classified as an interstate migrant worker, which is 18,000 rupees per month. So anyone earning less than 18,000 rupees per month and who has traveled from one state to another is covered under, for employment purpose, is covered under interstate migrant workers. They require electronic registration and self-declaration, and to register, they'll just need their Aadhaar card. There is another concept which we have also discussed in our previous webinars of the inspector come facilitator, where to try and get rid of the inspector Raj that used to that used to be there before. Now we are looking at a new concept of inspector come facilitator, who advises and facilitates compliance with this code, and also carries out the role of an inspector in fault finding and prosecution. So, like we discussed, there are several types of workers and employees that are covered under the code, and that have been properly defined under the code. The list is in front of you. So you have employees, contract labor, fixed term employee, interstate migrant worker, gig worker, platform worker, self-employed, unorganized worker, construction worker, home-based worker, wage worker, casual temporary worker, plantation worker, seasonal worker. And all of these different types of employees have been covered under this code. Coming to the Provident Fund framework under the code, there are three core schemes under this framework. One being the Employees Provident Fund scheme, which is your primary retirement savings scheme available, where the employer contributes. Under this code, the requirement is 10%, which may be 12% for specified establishment, and the employee contributes the same amount, which then goes into the provident fund. Now, the employee may voluntarily contribute more than 10%, but the employer is not required to match this increase in contribution. Then you have your employees pension fund for post-retirement benefit. You have employee deposit linked insurance scheme for life insurance benefits.
Kinjal, you have put up the excellent slide of the previous one, giving the various category of the worker, which is very, I appreciate very much. I would like to definitely record my appreciation to you, explaining all the type of the workers for this purpose, which has been brought in. Yeah, go ahead.
Now, when it comes to thank you. So when it comes to these benefits, if the an employer is paying for and contributing for these benefits for contract workers that he has engaged, then this employer has the right to recover full amount from the contractor. So we have discussed that EPFO coverage is for establishments having 20 or more employees. Then there are one establishments can also go for voluntary coverage that fall below having employees below 20 and give voluntary benefits to its employees. Um, then there is inclusion of new category of worker system, which is your self-employed and other worker categories, which will be notified. Then we are looking at contribution of 10%, which I mentioned, which will be matched by the employer. Then coming to deferment options, the government they may provide deferment options to notified establishments for up to 3 months. This is just to provide flexibility. Nothing has been notified as yet regarding this. And when it comes to insolvency proceedings for a company that is going into insolvency, EPF dues are treated as a charge on establishment's assets and will be given priority over other debts. In terms of for any kind of appeals, when it comes to EPFO, there's a deposit of around 25%, and then we're looking at penalties for non-compliance under this code, which is up to 1 lakh and imprisonment of 1 to 3 years, and any subsequent failures of 2 to 5 years imprisonment and fine of 3 lakh. Coming to ESI, so all employees in the establishments covered under ESI would be able to receive the following benefits, which is your sickness benefits for, in case of any periodical payments during sickness that is certified under the code. Then we're looking at disablement benefit for temporary and permanent disablement from employment injury, any medical benefits and treatments for insured person and the family, maternity benefits for confinement, miscarriage, etc. Dependents benefit for all the dependents on the employee in case of death from employment injury. Funeral expenses for funeral costs for the employee. Uh, as I mentioned before, the applicability is for 10 or more persons. And this excludes seasonal factory workers, unorganized sectors, plantation workers, gig workers. If they may even go for voluntary registration under ESIC, like for PF. And before, ESIC only covered selected districts, but now under this code, all districts of the country have been covered. And so before, before, if any employer would fail to pay ESI contributions, then and if the employee went to avail the benefit of ESI, and if the employer hadn't made the contribution, then they would not receive the benefit. But under this code now, the employee will receive the benefit regardless if the employer has actually paid or no. But then the ESIC will be liable to recover these benefits from the employer who is liable to pay these kind of benefits for its employees. Now, like I mentioned, employees in the hazardous sectors would be mandatory required to be registered and must follow ESIC requirements. And so The central government and state government will notify schemes for the unorganized workers, gig workers, platform workers under this code. Um, Again, like in PF, the government can defer or reduce employers' contribution for notified establishments. At the time of pandemic, any kind of national disaster, etc., for up to 3 months. And again, like in PF, for insolvency proceedings, the employer uh, so insolvency proceedings of the employer, there'll be a charge on its assets for these contributions and will be paid in priority as priority payment for contributions over other debts. Coming to gratuity, now gratuity is a mandatory benefit to employees upon termination of their employment, provided they meet specific requirements. This is for superannuation, retirement or resignation, death or disablement. So the key exceptions. I'll just run through the calculation, which is 15 days wages for each completed year of service. And in case if it's over 6 months, then even that will be included as 1 year, and it will be last drawn monthly wages upon 26 multiplied by 15 into years of service. And the payment must be arranged within 30 days from the date it becomes payable. And if not, then an interest would be paid, which will be notified. The employer will not be required to pay, and there'll be forfeiture of gratuity if there's if the employee has caused any damage to the property to that extent, or if there's been any kind of misconduct in terms of when it comes to moral turpitude under this code. Employers are required to take compulsory insurance for its gratuity liability. Now, this employer will be required to do so if he employs 500 or more employees. Or he can, or if he has 500 more employees, then it may establish an approved gratuity fund. Now, there was always confusion when it comes to fixed term employment. Now, fixed term employment, if that exceeds 1 year, then the gratuity will be payable, and it will be payable on pro rata basis. Whereas in other cases, the service will be for the 5 years, and then they will be eligible for gratuity. Gratuity inclusions have also included working journalists, which will be eligible for gratuity after 3 years of service instead of 5 years, like for others. Coming to maternity benefits, they are payment by an employer to a woman for a period of her actual absence related to childbirth. Now, establishments that this code covers are factory, mine, plantations, and establishments having 10 or more employees. And then to qualify for maternity benefits, the woman should have actually worked in the organization for at least 80 days in the 12 months immediately preceding to the date of her expected delivery. There are mandatory rest requirements. No employer shall employ a woman in any work during 6 weeks immediately following the day of a delivery or miscarriage or any medical termination of pregnancy.
Just to add here, apart from the maternity benefit under the old act, the new labor code actually mandated a compulsory medical bonus to all eligible women employee in case the employer is not providing any kind of prenatal or postnatal treatment facilities. So 3,500 per women employee has to be provided. And also, please remember, apart from the compliances, there is one more important factor is that displaying the abstracts. Certain kind of notification materials by the organizations are very important. Under maternity rules, under the labor code, it clearly insisted, even it has given the format, that what kind of format has to be displayed by each employer as far as abstracts are concerned. Proceed, please.
Yes. There is also restriction on arduous work under the code. So if the woman requests, pregnant woman requests, an employer must not require her to perform arduous work, which involves long hours of standing, which will interfere with a pregnancy and fetal development um, for 6 weeks from her expected delivery. The benefits will be paid at an average daily wage calculated 3 months preceding her absence for the period of her actual absence. Now, maximum benefit period under the code. So, as a standard, it's 26 weeks maximum, of which not more than 8 weeks will be preceding the expected delivery date. If the woman has 2 or more children, then the benefit is limited to 12 weeks with a maximum of 6 weeks preceding the expected delivery. In terms of adoption and commissioning mothers, they are entitled to 12 weeks of benefits from the date the child is handed over. And in case of death, then the employer's payable is liable to pay for the benefit for the entire period until the child's death, if the child so dies. Or if the woman dies, then the benefits are payable up to the day of her death. In case of miscarriage, medical termination, they are entitled to 6 weeks of leave with wages. Then coming to nursing breaks and creche facilities. So women returning to duty are entitled to nursing breaks daily until the child attains the age of 15 months. Then under this code, every establishment employing 50 or more employees must provide a creche facility, and the employer must allow at least 4 visits a day, which includes her rest intervals. Now, under this code, before every employer was required to do this to provide creche facilities, but under this code, the employer can collaborate with other establishments and create a creche facility. So that gives a bit more flexibility and less financial burden to them when it comes to provision of creche facilities for its women employees. They can be provided both.
Just to add one point, Kinjal here, please note under previous law, the creche has to be provided if there are 50 or more women employees. Please go and advise your clients immediately. Under new code, it is 50 or more employees, whether regardless of female or male or a combination. So there is a sea change. So previously who may not be falling under this rule have to comply this immediately.
Yeah. So then they cannot be unlawfully dismissed. This was there earlier also. If because they are pregnant, and on account of absence due to maternity leave, there'll be no wage reductions for nursing breaks. Then work from home to be provided with mutual agreement. And like sir mentioned, medical bonus of 3,500 rupees if the employer is not providing free prenatal or postnatal care.
There's an interesting question has been put up on this actually. Some employees pay maternity benefit to a woman employee when she is on maternity leave. Only some part of the allowances along with the basic DA is it allowed to exclude some allowances such as the conveyance allowance as she is not commuting.
See, the law says wage has to be paid. What is the wage defined as far as the woman employee concerned, whether she is working in the office or remotely or anywhere? But there can be a way out if your employment letter per se from the beginning clearly showing that this particular component of the salary is paid if you are only coming to the office. That you cannot change once a woman declared a kind of maternity. So otherwise you must pay whether she is commuting or not as far as her maternity benefit is concerned. And also I'm seeing a lot of questions piling up, Kinshal. We need to move a little faster so that maybe the definition parts are something you can glance through so that we can try to help them with more queries.
Srinivas, only interesting point you said, the employment contract, what it actually provides, whether conveyance is paid as a part of the element as a conveyance allowance as such, like any other allowance, or it is provided on the utility basis, that is number of days you deliver, you actually commute, we will provide or something, that will depend upon the case, though we cannot generally answer because it will have to see what is the employment contract, what is the nature, how it is done. Yeah. Go ahead, Kinjal. I think I want you to complete early because it's already 12:30, half an hour only you left out actually. As he rightly said, a lot of question answers. I don't think this time also we'll be able to complete all the questions. We'll try our level best. Yeah.
Yeah, yeah, skim through this. So
Yeah.
coming to employee compensation, so compensation under this code refers to specific financial payments that an employer is liable to provide to an employee in the event of employment-related injury, death, or occupational disease. This chapter specifically applies to employers and employees in specified um, sectors under chapter 4 ESI in specified sectors where chapter 4, which is your ESIC provisions, do not apply. Now, now for this employee compensation, employee is restricted to specific categories of persons listed in the second schedule. Now, this list includes individuals employed in railways, manufacturing, power, mines, ships, construction of buildings, bridges, etc., handling explosive, hazardous substances, etc. An employer's liability to is liable to pay compensation if a personal injury is caused to an employee by an accident or occupational disease arising out of in the course of employment. Then there are certain specific exclusions when it comes to liability for an employer. Now these include if the injury does not result in total or partial disablement exceeding 3 days, then they are not liable to pay. Then the injury which has not resulted in death or permanent disablement was caused by an accident directly attributable to employee being under the influence of drinks or drugs. And if there is any willful disobedience of safety rules, then they are not liable to pay. Now, there are certain computations for kind of injuries that are undertaken under this code, which we will not get into because there's not too much of a change there. Then, when it comes to employee compensation, it was earlier only limited to factories, but now the code specifies that it applies to all establishments, not complying with ESIC and certain additional other establishments also. Um, Now, previously there were a lot of case laws that were decided whether an employee should be paid when something happens if he's going to work or returning from work. Now, the code clearly specifies and includes these circumstances also. Then that once Then there were times when once this incident happened, the employer-employee came to an agreement, and for payment of compensation, but still the employee would go and sue the employer for any kind of injuries. Now this code disentitles the employee from doing so once the agreement is reached between employer and employee. Now, the payment of funeral expenses has been increased from 5,000 to 15,000, with an interest if it's not paid in time. Then minimum compensation under Section 81 is increased. Any kind of delay in medical examination to be condoned beyond employees' control. These are smaller, changes which we can, just skim through. Then, in case where the employee is not able to take up its own legal counsel, then the state authorities can provide, etc. So, quite a few benefits improvement for employees under this code. Coming to chapter 9, which looks at the gig workers, unorganized workers, and platform workers. Like we saw before, this is a new introduction. And this code tries to cover them also and provide them security benefits that are available to other more formalized sectors. And now, under this code, the central and state governments are required to create specific social security schemes, especially for these kind of workers. But these aren't out yet. Under this code, the funding mechanism for the schemes that are to be established by the government, and the funds for the social security of these gig workers, platform workers, is to be funded through the aggregator who associates with these gig workers, platform workers, and the contribution would be 1 to 2% of the annual turnover. Now, this is big. I mean, given the turnovers that these aggregators are looking at, with the likes of, the annual turnover of Zomato or Amazon, for that matter. So this is a big change when it comes to aggregators, and their responsibility when it comes to providing social security benefits to its workers, gig workers and platform workers. These funds can also be funded by central government, state government, the gig workers, platform workers, and the aggregators. More rules, more schemes need to be coming out for us to get more clarity under this. Now, but then this one contribution of the aggregator is capped at 5% of the amount that they will be required to they would have been required to pay to aggregator, to its gig workers and platform workers. So their liability in terms of payments to be made to gig workers and platform workers, 5% of that would be the cap on their contribution for their benefits. Like I mentioned before, the concept of inspection cum facilitation has been introduced under this code, where now inspections is more web-based and electronic. Before, it was very arbitrary basis, what the inspector, whims and fancies of the inspector, essentially. It's more systemized, the selections are more randomized, and when it comes to inspections, then inspection reports are to be uploaded electronically to ensure this timely reporting when it comes to various inspections. Everyone covered under this code are mandatorily required to register, and existing registrations under the previous code will be carried forward for this, and um, registrations have been simplified much more under this code, where when it comes to migrant workers, gig workers and all, for their registration they just need an Aadhaar card. Then records and register are to be maintained electronically. And so a lot of emphasis has been given on maintaining records under this code, in terms of various different types of employees employed, deductions, statutory benefits provided, things like that. Then, when it comes to returns and disclosures, returns are now to be filed electronically. There must be display notices at the workplace when it comes to this code, essentially, and their employers are required to issue wage slips to all employees. Now, the architecture under which this social security of India is to be functioned is through the Central Board of Trustee for Employee Provident Fund. Then we're looking at um, Employee State Insurance Corporation for ESI schemes, State Unorganized Workers Board for state level implementation and monitoring, National Social Security Board for gig workers and platform workers. Now, this will be the board coming out with schemes for gig workers, platform workers. State Building and Other Construction Workers Welfare Boards for managing cess that they've collected from developers, and welfare for construction workers. Essentially, we are looking at center and state to come together and work collectively to ensure that the social security benefits are properly passed down to the beneficiaries under this code. Now, looking at the impact of this code has exponentially expanded the coverage for Social Security. A lot of people were being left out for Social Security coverage, which has now been included under this code. These include gig workers, platform workers, unorganized workers, self-employed persons, aggregators, which were also excluded, and any kind of it has tried to include non-traditional employment relationships. Then we're looking at increased compliance obligation for employers. Now, this can be this can go two way, essentially, because a lot of physical compliance requirements when it comes to physical registers and all, which have now been done away with, dealing with Inspector Raj and all, will be reduced. So there are times when compliance has reduced for the employer, but on the other hand, there are a few other compliance requirements under this code where now more employees are covered. So the benefit cost to employers, has increased. Then you're looking at wider applicability of employee and employer. So more employers are covered, more establishments are covered, and they are required to provide for a larger set of employees and workers. Then this code is trying to formalize the workforce. This includes your gig platform workers, self-employed workers, and ensure they get coverage. It's a more welfare-based model and not an employer-employee model. So there's no forced employment relationship, and social security is through separate schemes. So there is kind of a regulatory oversight without disrupting business models as such that now exist today, which didn't exist before. Then, if you see, there have been with greater coverage for more number of workers, there's greater financial security now that is now being provided. Then there are several areas where the government has allowed flexibility to itself to manage disaster and crisis response, where they have allowed deferment and reduction of contributions during certain emergency scenarios. This now coming from their experience when it came to dealing with the COVID crisis. We're looking at strengthened enforcement and recovery mechanism. Now enforcement in terms of easier registrations, more digitized, everything's more digitized, transparent. And when it comes to enforcement and recovery, we're looking at increased penalties, imprisonment for serious defaults, things like that, and penalties that are more defined and more up to date than they were earlier. We're looking at strengthened enforcement and recovery mechanism as per that. We're looking at improved access to justice and welfare. So given that now things are more codified, employees have better access to tribunals where they are not overburdened under this code. Then we're looking at long-term economic and social impact, where now workers are better protected when it comes to retirement, etc., giving them a better life in the country. Um, After the formalization of the workforce, there's improved labor market data that is now available. And this kind of benefits and protection essentially strengthens social security, workforce stability, and productivity in the long term. So with that, I will open the floor for questions, which I think everyone is waiting for.
Sir, you're on mute.
Thank you very much, Kinjal. You have very nicely and artfully made the presentation. You have taken through such a complicated act and combining things and just format it. You have done your level best. My congratulations to you. We'll go over the question answer, whatever the things are here now. So what we'll do is we'll just see. Please explain the outsourcing core function, especially whether the IT head and finance head could be appointed on consultancy basis. Srinivas has already said what is the core activity. Core activities means the activities in the firm is informed. Because when you talk about the finance head or IT head, they are all service providing functions because service departments. So those things can do. Yes, Srinivas.
Yeah. See, there are many questions. It is difficult for us to go by each question, but I roughly figured out at least 20 odd questions under 3-4 heads. I will try to address that so that most of the participants would be benefited out of that. That FTA used by the labor code is fixed term employee, not the popular jargon our HR uses of full-time employee, point one. Now people are confusing consultant with contractor, with outsourcing, with FTE. Particularly, just to give example, hiring a financial guy or a IT head, or putting a kind of guy to take care of bookkeeping, accounting, these things are not coming under core activity. So you can continue to do with them by allowing them to be outsourced. Like most of the HR functions are now payroll processing, even CFO services, now legal services are outsourced. So these do not fall, according to our view, as a core activity, so that you can continue to do that. Having said that, if it is
actually, when you talk about the core activity, one has to actually refer what is the memorandum of association of that company. That is, that company is registered for what purposes? What is that activity they are going to perform? That is what it will form actually when you take the activities. But what they are all referring is, as you rightly say, these are all service departments which are associating to achieve the core activities of the company. That distinction they have to make. Yeah, go ahead.
exactly. Now coming to that, having said that, you can outsource those activities or you can continue to engage them on a consulting basis. When you are entering a kind of fixed term contract, like say that guy will be working for 2 years, 3 years for the example purpose. At that time, they are subjected to the gratuity. Now I am here mixing with outsourcing with gratuity because there are a lot of queries on the gratuity. Again, those half liars and influencers created a kind of ruxas in the market that gratuity has to be paid after 1 year of completion of service. If you are on the regular employee, you are on the regular payroll of a company, your gratuity will be governed by the same provisions. Unless you complete 5 years of completed service, gratuity will not be paid. So the rule remains same. Then who is going to get this 1 year gratuity is those fixed term employees where you know from the day one that I am not going to absorb them on my regular payroll. I am going to hire in a given case like 3 years. Obviously, in that case, those people will entitled to a proportionate amount of gratuity. Having said that, I will give you an example. 12 lakhs is a consultant per annum package we have agreed. That means 1 lakh per month is his service. I hired him for 3 years. After completion of 1 year, whatever the reasons, he wanted to part with us. At that time, he is entitled to the gratuity. Now it is up to the company, instead of giving every month 1 lakh as the payment, of course, subject to TDS of 10%, you should be providing for the gratuity also for a consultant. Okay. It means instead of paying 1 lakh, I'm just saying roughly example, say gratuity is 10,000. I would be deducting 10,000 from his monthly pay of 1 lakh. Of course, subject to TDS anyway. The remaining part only I'm paying to the consultant as every month compensation. At the end of the year, if he left, I'm still left with around 1,20,000 of his cash, which is part of his package we agreed that I'm paying without extra costing to the pocket of the employer. So you have to keep that in mind in balancing the gratuity. Now, someone also asked, there are two ways a gratuity provision for regular employees. Obviously, you can go for a fund or you can go for an insurance scheme under LIC or SBI. Both are options given to employer. Law do not mandate compulsory. You have to go for either this or that. You can choose, but one of them should be in place because it should not create a big accounting impact as far as books of accounts of the company is concerned. Now, some more queries have come that today I am already in January. I am supposed to file returns. What should I be do? Should I be waiting for new rules or new forms? No. During the transition period, obviously, as sir already replied to in the query also, you should be complying as the avenues available to you. Just I'll give you one more example. Labor courts prohibit the jurisdiction of civil courts and labor courts. What does it mean? Today there is an employee-employer dispute on January 17th. Which forum they have to go? Where is the state tribunal? Where is the industry tribunal? Where is the national tribunal? Delhi High Court already issued notice to the central government. Till that time, obviously, I will go to the existing venues and I will continue to honor the provisions and filing of returns as per the new current rules and current forums and current avenues. Once the new avenues are available, we have to shift it to that. One more question came up that whether registration under labor codes is mandatory. The government is actually contemplating a kind of probably a kind of Aadhaar for companies type. I can say how they can, because previously multiple departments were there with multiple sovereignty. Now they would like to bring one registration. Of course, even the social security code registration falls under OSH code. There is a form 1 provided for that, under which an employer has to register so that they will be given one kind of unique identity number. Why this is mandatory, I will tell you. One more new concept issued under the labor codes called Aadhaar seeding. What does it mean? As we said from the beginning, the code is meant to cover largely for the unorganized sector, gig workers, platform workers. They are still not going to entitle to PF, ESIC and all these benefits. Government is putting some kind of fund, and how that someone asked how the turnover is calculated for the purpose of the fund. Still the rules are not in the public domain, so we have to wait for how the turnover is defined by the government as far as that fund to be deposited by the employers engaging gig workers. Now the other seeding is that how to capture these interstate migrant workers, building workers, all these people, that their Aadhaar will be linked to the employer's registration number. Sometimes these gig workers or construction workers will be working in multiple organizations. So that by the Aadhaar seeding, government will connect the data of employer to the employees working in this unorganized sector, so that the benefits, whatever can be smoothly processed and paid or health benefits can be extended to these forums. So these are some of the major queries I have seen, and rest we can go through the queries right now people are putting in.
Do we have to change the salary structure? Please refer our earlier webinar. We clearly talked about it. That 50% rule, you can go through the earlier webinar. We will not take up that. The labor law codes are now from released transactions staff follow, which is the old rule that we already explained. Please suggest whether the structure should be considered performance pay as part of the salary structure with a 50% limit to CTC.
One more point here I would like to add. Again, there are some good number of queries on this. Law do not recognize any word called net salary, take home pay, gross salary, CTC. These are all the industry practices. Law, what it defined the wage part, saying that whatever the remaining part, you name it, the nomenclature your company has, you continue. They are not going to stop your freedom. But having said that, the entire amount should be 50% of that should be the wages. Like someone also put the query that I want to give HRA 70%, 60%. Absolutely, you can give that. The limited point is law says, suppose for our example sake, the basic salary is 40,000. Other allowances are 40,000. Total gross wages here is 80,000. Obviously, you are matching with 50% wage should be the basic plus DA plus retaining allowance. So 40,000 is the basic. Remaining allowances, whatever you name, are another 40,000, 80,000. Because you have decided to give 70% as the HRA, your remaining 40,000 is enhanced to 60,000. Now, what is the total wage? 1 lakh. Automatically, your basic is now again adjusted from instead of 40,000 to 50% rule, 50,000, which will impact your leave encashment, gratuity, all these provisions. So be careful if you want to provide HRA unlimitedly, you can do so, but automatically you are pushing your basic percentages.
Yeah,
now,
whatever
yes,
way you design your salary, ultimately total divided by 2, that will be taken for granted for all the contribution. That's it.
absolutely.
So nothing is prohibiting, as Srinivas puts it. You may term it whatever way you want, but ultimately the 50% of the totality should go for the social benefit. Yeah.
And many queries also coming out, please suggest us the structure. See, it's not that one fits for all, but government itself in their facts issued very clearly quoted those examples. That what should be the compulsory part, remaining part they gave the flexibility. So you maintain that fixed part as the fixed component and the remaining you can play the way you wanted. So you will be matching with the salary structure of the company. Rather, actually, we are defining that this should be the basic. One more dichotomy here. Government has now defined HRA is not considered as part of that 50% wala wage. It doesn't mean that you stop giving HRA. Point two. Now, one more confusing thing. In the state of Maharashtra, there is a specific law for HRA passed in the year 2008. Every company in Maharashtra must provide for HRA as a part of salary. Here it is a compulsory component, but it is still not reckoned as part of the 50% component defined by the government for the purpose of various calculations. So you have to balance. That's why probably we can say the labor codes are effective November till the month of April. Unless you start preparing for yourself or your client today, you will not evaluate a clear position that what is the right approach for the next financial year onwards.
If retired employee services are extended as a consultant for another 2 years, should be paid the gratuity.
See, gratuity beyond statutory limit is optional. First of all, whether even 10 employees or not, you want to pay gratuity, your call. I worked in a company which provides gratuity the moment you complete 6 months also. It's up to you. Once you considered him, now labor codes first time put what is the age of retirement is 58. It's not necessary that you have to stick to 58. You can have your own internal policy. If post that 58, that extension 2 years is also considered as employment, obviously you can continue to do the gratuity and probably other deductions. Otherwise, just he is a mere consultant and you want to be gratuitous to him, you can always compensate him with any other fancy name.
Srinivas, you put it very correctly. In many of the organizations, I also come across the retirement age is 60. Because people, they wanted to keep him. So what they do, they extend his service. When the extended purpose, actually his retirement age is actually enhanced from 60 to 63, 64, 65. He continued to get the benefit because company wanted to take care of him. But on the contrary, here if he has retired and he is employed as a consultant, that means the employment contract come to an end. So once the employment contract come to an end, all your retirement benefit, etc. and all, you are no longer obligatory. It is between the employer and employee what they want to do, how it is actually structured. Yeah. Generally, MOU is very exhaustive, and the CEO may have the large number of the active mention in the company's activities in the main object clauses. It is not the question of main object clause or ordinary objective. What is the company's core activities be carried out? That is all. That is the test you have to put. I generally refer to MIA because MIA talks about the activities, but what is that you are carrying? You may have about 3 or 4 activities. Out of that, you may be carrying one particular activity. That cannot be outsourced. In fact, very interestingly, Srinivas has put, if you are actually the IT services company, he quoted the very nice example. Today, there are only a handful of people who are actually in the company, whereas the main activity of the IT itself is outsourced. What it will happen, that is what he touched upon. That call, you have to take it up. Gratuity we won't take because he has already explained. Best presentation appreciation. Okay, this is the CEO. CFO in the organization has to be employee in any case, company side. Yeah, you see, it is not the question of employee or something like that. You need to have the CFO. CFO can be employed as a permanent basis, permanent employee, or you can employ on contractual basis, also contractual employment. There is nothing is there. So it is not like that you cannot be employed or something like that. It can be. Because many organizations I know, they actually employ people for a period of 5 years and again mutually agreeable like that, they do it. So that is up to the arrangement which is being done. Is the canteen is compulsory for the industry where more than 50% or 100 people are engaged in the showrooms?
Again, it depends on the category under which the showroom was registered. And according to that, they have to follow the limits. And some of the new points have come up, sir. Bala sir, actually, what is retaining allowance? Actually, Kinjal has mentioned in her presentation, retaining allowance generally happens like
the seasonal industry.
Seasonal industry.
It has been explained very well in the earlier seminar. Please go back to the earlier seminar. Because whatever the earlier seminar we addressed, I already given the link also. And in fact, these are all disseminated through the YouTube. You can actually access to that. She has very nicely explained. It is because of the seasonal industry, because they want to retain them. That is why retaining allowance is paid. That's as simple
like
as that.
Sugarcane industry, there is a seasonal crushing. So till that time next season comes up, you don't want those employees to go. Obviously, you are paying some kind of elements which may not be exactly equal to the salary level. What we call typically under previous law subsistence elements, which is roughly coming to 50% of the basic wages. Like that, companies tend to pay that.
I argued the examiner for the trade work under the trademark registry at the CGPDCM Mumbai for the period of the 11 months. Or they deducted 10% salary credited to our saving bank account. They do not provide any receipt or evidence of the salary except the appointment letter, or we have faced the problem in showing the salary, either the provision that we can ask them to get the salary proof of it or tax with the employment. Is it the 2019, 2022, 1 month or 3 times? Here, where is the question of proof of salary received or something like that? Because the moment Form 16 issued, that itself is contain everything. When you are actually filing your own, Form 16 is going to suffice your purpose. So that is the issue here. I don't see any other things here.
Superannuation age for EPF, PF under the new codes, which I already told it is 58 years defined under Social Security Code. Second query, if company is paying ex gratia every year, irrespective of performance, will it be part of wages or excluded? Now, law said very clearly, these 3 are important components of the wage. Rest all, you can be free to do that. So you can say overall gross wages of an employee includes this ex gratia, but the moment you are adding that ex gratia into the components of allowances, you are automatically pushing the second half of basic and other things.
Yeah, automatically that 50% rule will come up. That's all.
Exactly.
You have to see that 50% rule.
Yeah.
Whatever you pay, apply to the 50% rule. That is the thing. What is the implementation date of the ESI Act after the new code? He has already explained enough, I think so, in this. There is an old Supreme Court judgment staying coverage of the construction worker from the coverage under the ESI. Should the confusion companies address coverage of their workers under the ESI considering the implementation of the new Social Security Code?
See, that may be a case. That's why if you see many of the previous things under labor laws were not clearly defined. Maybe by way of clarification, GO, circular, or kind of court judgments, these are all were either complied or not complied or exempted. Now under the labor code, which is going to address if these rules comes up for as far as ESIC is concerned, covering even construction workers, they must fall in line because now construction is one of the biggest activity going on in last 20 years in India in a regular phase. It's not even a seasonal kind of industry. And I'm not going to be surprised if the central court rules will include construction workers under new SIC rules.
Our gratuity payable if the probation period of more than 1 year deemed to be not permanent employee. I think you got a mix up here. The whole idea is permanent employee means the person who is employed till he retired the age of whatever it is, 58, 60, 60, whatever it is. The eligibility of gratuity comes only after the completion of 5 years. That still remains, that doesn't change. The only case is check the fixed term employment only, as he explained, that changes. That is all. Because whether it is a probation or not probation, etc., for the continuity of the services, everything will be calculated. CFO of the Roth's organization has to be employee in any case.
We addressed that.
Yeah, that we already addressed it. Canteen, we already addressed it. What will be the general PF rate in the new labor code? She has already explained 10% is the thing wherever certain specified industry is 12%. Please do explain outsourcing core function. That he has already explained, I believe. We will not get into the detail now. Have encashment on death and enhanced dependent benefit on the death on duty. Leave encashment on the death and enhanced dependent benefit on the death on duty.
So we did not exactly understand the query, but leave encashment is supposed to be due and payable. Generally, it happens when employee leaves the organization, when he retires. Of course, in case of death, eventually it will be paid to dependents. If it was enhanced, obviously they are eligible for the enhanced leave enhanced.
Now, one thing, if I understand correctly, I do not know, but as a question itself is not clear. Leave encashment, whether it is death or otherwise, it is actually payable. Whatever is actually artist credit, that is number one. When we talk about the enhanced dependent benefit on the death on duty, normally what happens, many organizations, when it comes to the gratuity, they enter into a scheme that if any untimely death occurs during the time of the duty or something like that, the calculation of the gratuity will be done as if he has served till the period of his retirement age. That is most of the companies, they normally do have that. If that sort of a things is there, then in which case the enhanced benefit, he will get it. Otherwise, normally if he retires, he will get the gratuity number of years he has served. That is what I understand if I go through these questions.
One more query, sir. If employee is terminated illegally, that itself is a different criteria. Now, the second part of the query, he was in regular service for 4 years and 8 months before his termination. Of course, he can challenge his termination. But as far as gratuity is concerned, there are proven court judgments that if an employee need, when we say generally 5 years, then when it comes to the 5th year, the law clearly again articulated by the court judgments that the number of days of completed service in the 5th year, this will not be applicable for the 1st year. So if he is completing 4 years plus 240 days, obviously he is eligible for full 5 years gratuity. Hope we have clarified that.
Yeah, absolutely right. How should the annual return be filed as per the this we already addressed, because whatever the new rules are saying, you'll have to go by the old rules.
Sir, you see this important query. We have only 10 to 12 core team.
Yeah.
And rest of the staff around 1,200 are under projects. So this is what even we are right now addressing. No problem. You can have that. Government is not exactly stopping it. As someone said, is outsourcing is same as engaging contract labor. So you need to understand why you are doing it instead of a regular employee. If you see under the new codes, even someone is considered as a contract. See, new code did not prohibit contract employee, right? So still we can engage contract employee. Then they are also still subjected to all the benefits, not exactly on par with your role, but other health and safety benefit. Even in case of retrenchment, there is a reskilling fund, 15 days salary to be paid. And also there are, Bala sir, there are a few more questions, just I'm grouping that. Many people asked about, shall we be paying the PF, ESIC of the contract employees, or how it is to be done? There are any way you can do the way you wanted, which is comfortable. The important point was that under the new labor codes, even contractor is also recognized as an employer. That is a very good change, point one. Having said that, new labor codes explicitly did not use the word principal employer, immediate employer. But still, for our discussion purpose, we have to use it. If we are the principal employer, engaging a contractor, obviously through them engaging 1,200 odd workers, we personally suggest that you better always ensure the compliance by the contractor at the first go. Obviously now the pay date is 7th on or before of the following month 7th. They must pay the salaries. They have to give you the proof of the payment of PF, ESIC, if that is a case of month of bonus, all this. Having satisfied for those evidences, then you must be disbursing the contractor bill. You are not actually paying the salaries of your contractors or those their employees. You are just paying a service bill. So you must be, if you are paying without these evidences, obviously you will be stepping into the shoes of those contractors, and obviously the government can extend their claims to you.
So the ultimate
Okay.
responsibility falls on the employer, even though contractor has been identified as an employer.
Yes.
But if you're employing contractors and you have contract workers, then it is the responsibility of the principal employer to ensure that the benefits are paid for. And if not by the contractor, then the principal employer could pay, but then he has the right to recover whatever contributions he's made for the contract workers from the contractor.
Let me share with my personal example on this particular matter. I was working as a controller of accounts in one of the company where we has to given the contractual, jobs. So where he employed the contractual labor, we used to check up every monthly whether the compliances regarding to provident fund is deposited, ESI is complied with, all the thing I used to personally check up. Wherever I have come across the PF is not paid, I used to call him. What happened? Is there no money surplus, etc.? We'll do one thing. We will actually pay the PF definitely, and then next month we will get deducted from our salary. I used to ensure that. So as you rightly say, it is the responsibility of the principal employer to take care of the compliances, what he is supposed to do by the contractual people. That is very clear.
One more query that whether 50% of the incentive can be considered as part of wages. The wage definition under the wage code itself clearly excluded with the word bonus. In corporate world, we use the word incentive, right? So any bonus or incentive other than the statutory one is generally do not form part of the wages. Their employer can define as a CTC. These things can come under their own CTC, but not the gross wages.
Yeah, this was actually discussed in the earlier webinar also. We said actually when you talk about the incentive performance, whatever it is, these are all over and above what is the benefit extended depending upon your performances. That is what we said actually last time also. Okay.
Gratuity is payable to contractor employees, not our responsibility. It is the responsibility of the contractor because they are into the business of contracting employees. So obviously that particular employee continuing with the contractor for years. So it is their provision to make all this, and as a principal employer, while disbursing their monthly bills, better we need to check whether they have made sufficient provisions under that. Otherwise, that liability may fall on us. And any legal obligation, if we consider project staff as regular employee, it is a welcoming thing. If you want to consider your project staff, that is what we are saying. If they are falling under your core activity, obviously you have to be placing them on par with your regular employees, so that you have to provide for those kind of benefits, cost, and other things that will obviously inflate your cost of CTC. That's the only thing you have to do. Construction, when we say core activity cannot be outsourced, does that mean construction companies now cannot outsource and bring all workers on its own road? See, that's what the exception said. The generic sentence is saying that if your industry's nature itself is engaging the contract labor, so you are not required to follow this procedure. There is an exception. So if construction industry is fitting into that kind of criteria, they need not enroll them everyone because of this narrow interpretation. So you can stick to those three exceptions test, and also the definition itself under OSH code given another level exceptions. So this 11 plus 3 or 14 exception test you apply to the core activity, that itself gives you answer. Rather, as a panelist, we are advising your company without knowing much details. There are 14 exception list is available. Sir, I think they exhausted. We could manage their Q&A
I think by and large, your address now, we are already 117. What I suggest is, let me see anybody has risen the hands actually.
Which books you recommend for further reading? Golden rule is always stick to bare act.
I think there are 4 people have raised their hand. We can permit them to speak. We can try
Yes,
to
sir.
address those questions. I think, yes, Chirag, you are there. Prashant, you are there. Any one of you can unmute and you can talk actually.
Yeah, hi. This is Sushil Mehta, husband of Ruchi Mehta. I'm also a CS lawyer. So, quick question about what we are getting a query from most of our clients or maybe colleagues is regarding the fixed term employee term getting expired post November 21st. So, as per the applicability, they are eligible for gratuity. But thing is, for example, they have left the organization and it was due for say for and the gratuity was payable and hasn't been paid so far, and the holiday period has started. Now we are sitting in January. So if they initiate the payment now, the interest portion is also payable. But what we understand is that interest portion applicability is not been notified yet. So, what would be your advice to such kind of cases where fixed term employees has terminated and company is eager to pay, but what should be done with the late payments?
See, the clarification has come up here. I'm not saying from the department point of view, but over the period, industry has discussed and maybe some professionals expressed that I would like to convey. The new labor codes benefits per se are applicable to regular employees. If we are doing their F&F, obviously their wage has to be adjusted. Of course, not in a pro rata way. If someone is actually leaving the company in January, then November, December, probably the part of the January salary will be revised calculation as per new wage definition. As far as FTC is concerned, it is not, I don't think so, the intention of the government that उनको बुला के आप gratuity दे दो. No, you are not required to pay them gratuity if the term is already ended by thing. So the first, probably the lot is eligible is on November 20th of 2026 only.
Okay, so the only apprehension the client may have is like, for example, because it was a fixed term employee and the news about the applicability of gratuity on them is in the market, so they may come up and say so they are ready to pay, but only component of interest of delayed payment is also something which we said like okay, it's not been applicable yet, but since they are eager to pay, you can compute on the same rates if to be on safer side maybe.
If your client is willing to pay, let them pay, and clearly showing that as a gesture of goodwill, as a voluntary thing. So let them not show as an obligation. The moment you show it as in such a way, the document, the whatever way you are doing this payment, they have right to claim tomorrow. It's not that everyone will quietly take their gratuity amount. Otherwise, the view emerging is as last stands today. It is not the intention that on November 21st, someone FTA term is over and you have to pay gratuity. It is not the case.
So your view is like it should be taken from effective 1st April 26 onwards, or
No. November 21st onwards, but their 1 year term completes only after 12 months of complete service, right? From now.
okay, so from 1st November, whoever completes 1
21st
year.
November.
Okay, got it.
In that way, if they want to pay voluntarily, I'm not going to stop. Please let them pay, but show the
Okay.
intention clearly that you are paying out of as a gesture.
Okay,
Yeah,
because they're treating it as like from 1st November, whoever has completed 1 year, they are treating it as like gratuity payable.
Yeah, you can always go beyond the regulation and you can do voluntarily whatever you want to do it. Yeah. Yes, Chirag.
Hello.
Yes, Chirag.
Good afternoon, sir.
Yeah.
Sir, I have two questions. First question is related to 15% in kind. As per the section 2Y of wage code, sir, we are giving food coupons to employee. So, as per 15% in kind is the wages would be added back to the basic wages. Means we can say basic plus DA we have to do 15%. So that should be added in gross salary, or we have to added in basic plus DA.
Need to check quickly. What is your second query?
Second query related to 15%. Hello.
Yes,
Yeah.
go ahead.
My second query related to the 15% of the gross salary related to basic and DA. If I give more than 15%, 52, 53%, and if allowances goes more than 15%, that should be added back to wages. In that situation, what is the scenario?
I will just read the exact,
The first
requirement under
point,
the law.
first question answer is it has to be added part of the wages only. The 15% provided in kind.
Hello, sir. Your voice is very slow, sir.
The first
He-
question answer is that
What is the answer of first
15%.
question, sir?
First question he said this has to be added to the wages. It has to be added to the wage. Yeah.
That is the limitation of 15%.
Yeah.
Yes.
Kinjal, you are coming back on that second question.
So second question is that if my basic is 52%, for example, and I am giving other allowance, say for example CCA, so will it impact anything? Will my CCA also be considered as wages or not?
See, don't cherry pick one particular allowance. Law clearly says in the wage definition itself, the proviso, what should be the basic plus DA plus retaining allowance clearly defined 50% of your overall wages.
Yes, it
But
is
if you
above
are
50%.
if you are loading, don't go by 52%, stick to 50. If you are loading your allowances part, as I said, that 50% is coming 40,000 rupees. The other allowances should be another 40,000. That means 80,000 is the gross salary of that employee, 50,000 is the basic, 40,000 is the basic, 40,000 is other allowances. If you are loading more in the allowances by adding another 10,000, so his gross wages are 90,000. Then his 50% rule is actually distorted, right?
No.
Instead of
My
40,000.
question is that, say for example, my total wage remuneration is 20,000. Now out of 20,000, if my basic is 11,000, so I am complying with more than 50% of the limit. Now
Yes.
rest of the 9,000, say for example, it is HRA and CCA and other components.
Yeah.
So will something attract on CCA or not?
See, city compensatory allowance, all these things are not included as far as wage definition is concerned. So you are free to design all those things the way you want it, as long as that salary remains 20,000.
And even my LTA is in other 9,000, then also there is no issue.
Doesn't matter. Law gave you the flexibility. Only they are concentrating on the first 50%.
Perfect. Okay.
As
Okay,
we are
Henry's-
giving LTA to every employees. So as per the definition, as per the Supreme Court judgment, Surya Rosni judgment, if universally we are paying any kind of allowances to all the employees, so will it attract to the part of wages or not?
No, see, time being, there is an excluded list. Okay, I will put it in reverse way. Law now defined that what should be included in the wage, and others can be part of the wage but cannot be included for the purpose of calculation. It's not prohibiting you to give HRA, CCA, LTA. You can give the way with the different limits, no problem, as long as you are managing the 50% balance.
Okay, so 50% rule we have to follow. If we are
Absolutely,
giving any
golden rule.
allowances universally to all the employees, that we no need to calculate. We just means it is not a part of wages.
Henry is actually saying that he is unable to unmute himself, but extending his query. He says, if I extend my project contract term for 2 years, if we hire the staff for the people, we have to treat them as a fixed term project, or we have to pay gratuity to them, or shall we treat them as a regular employee to stop the gratuity applicability? Even our project term is only 2 to 3 years.
See, in this query, if you are engaging an individual directly, he is called as FTE. Obviously, you have to follow the gratuity rule even for 2 year, 3 year proportionately. If you are engaging a contractor or an agency, a company, which in terms provides workforce to you in 50 or 100 number, it is not prima facie your headache of the gratuity. Obviously, the contractor, the immediate employer has to take care. If he fails to do so, as a principal employer, you have to take care of them.
I think that's all. I think here we are already closer to 1:30. I think we close the session here. Before I close the session, Srinivas, I would like to ask you to say a few words for the benefit of the people on this, because we are still in the learning stage and there are rules are expected to be announced by the state governments, etc. All those things are there. Your last summary words, please.
See, as we said in the beginning also, as a conclusion, do not wait for any kind of deadlines or dates. Accept these are not amendments. It is not a new version. It is completely reset of entire labor codes of last labor laws of 90 years. Like the Employee Compensation Act 1923 previously, Payment of Wages Act 1936. So have a proper perspective and go back to your client if you are a professional or if you are industry guy. Go back to the drawing table by the finance team and HR team and properly understand the spirit behind this. And if you think compliance is expensive, as Kinjal said, there's a lot of compliance burden. Try non-compliance under new labor codes, which is very expensive. In case you struggle to understand our thing, obviously you can seek help from the various professionals or agencies who can guide you on this. And obviously part of these sessions, knowledge sharing sessions, we are happy to contribute to the extent possible, to the extent we are learning every day. It's a great effort by Mehta and Mehta to conduct these kind of sessions.
Thanks a lot, Srinivas. First of all, let me congratulate Kinjal once again for the overall presentation. She has done very, very nicely, elaborately explaining almost the different type of the concept which has come into the new wage code. That is one thing. I must congratulate to her for her efforts. Number two, my sincere thanks to Srinivas because of his varied experience over a period of more than 2 decades or so. He is able to throw us a lot of incidences, lot of practicality. Definitely, it has helped. Definitely, even I got a lot of learning even today's session. Although I've been continuously going through the things, etc. But still, anytime we read, we come across a new thing. That's what is happening. It's all a quite understanding and learning session. Great thanks to Srinivas once again. Great to the participants. Please excuse us. By and large, we have tried to address all the queries summarized and other things and all. Due to the positive time, we'll have to close at this particular time. If there are any particular things left over or something like that, we will definitely come back. And I've been seeing it actually, can the PPT can be shared, whether the webinar will be available, etc. In fact, I put the link actually where our webinar is actually available. It is the YouTube, which is disseminated after the webinar is recorded. It will be available after 2-3 days time. Once it is done by our editing term, you can access to it, you can contribute, you can take it. PPT is not generally shared, but the disseminated webinar, which is actually distributed, will contain the PPT. You can go through it. Thanks a lot. Hope to see you next week. We close the session with this. Thank you. Good weekend. Good day to all of you. Excellent, Srinivas. Thanks a lot once again.
Thank you, sir. Thank you. I'll take your leave.